it basically means that you guys need to have a certain level of advanced knowledge on how to manage these OTPs. OTPs for property investors are a tool. They're a tool that you use in order to be able to secure your deals. So what I'm going to do today is I'm going to start right from the beginning. I'm going to explain to you what OTPs are. I'm going to explain to you, how they originate, what their main purpose is, how they become binding on people, what they should look like. Because believe it or not, there is an importance to that. I know that people don't like listening to talks about anything legal, and I don't intend to bore you with legals, but there are certain very basic things that you need to tick in order to be able to submit an actual formal and valid OTP. So just to begin with, as an introduction, those that don't know me, my name is Bruno Simão. I am a property, commercial, and tax attorney. So all these things come together. Why? Because as a property business, as a property investor, it's not just about transferring properties from one person to another. My conveyancer does that, and she's really good at what she does. I am not a conveyancer. I don't focus on the deeds office. I don't focus on the actual transfer of the property from A to B. I work in the structuring and basically the transactional space. So as a property investor, if you come to me and say that you want to buy a property, I start asking you the imperative questions about, but does the property make sense? Does it make business sense? Is it feasible? How does the contract protect you? How can we structure this to your advantage? Do you have to pay VAT? Don't you have to pay VAT? What are the total costs if you do it this way? What if you do it that way? Do you use a trust? Do you use a company? All these questions are very commercially orientated because you are a business. And because you are a business, you need commercial advice sometimes when buying properties for investment purposes, not simply conveyancing advice, because conveyancing advice will be limited to just the OTP and what the OTP should contain. There's more that you need to ask yourself as a property investor in the legal and tax space when it comes to business transactions and investing. So that is my forte, and that's why I speak to investors, I speak to corporates, I speak to companies involved in the property space to advise them how to best do their property deals, how to best manage their properties. Now, just very briefly, so you guys have an idea of what today is going to look like. Start my video. I don't know if that worked, but so what the session is going to look like is it's predominantly going to be dealt with in two components. There's going to be the components on the fundamentals and then the very specific clauses that you need to consider. You can't do the clauses without doing the fundamentals first. So we're going to try to cover both of them. And then the Q&A, so I will check towards the end. I don't have access to a Q&A box here from the looks of it, so I might have to ask Kali to jump on towards the end and let me know if there are any questions that need to be answered. I can see a chat box, so I might be able to answer some of the questions on the chat box. Now, so let's get it started. All right, so first things first, for those that don't know, getting your OTP right. We speak about OTPs. We speak about the fundamentals of OTPs. We speak about checking your OTPs. Now, do you know what an OTP is? So that's the first thing that I suppose is the most important thing that actually needs to be answered. OTP stands for an offer to purchase, right? Offer to purchase. Now, what you guys might not know, and I won't bore you with this, but contracts in South Africa consist of two actions: an offer being made and the acceptance of an offer. Once that happens, you have a contract. So an offer to purchase, by its very nature, is you as a purchaser making an offer. I want to buy your property, sir, for 1 million rand. Until that person accepts the offer, it's only an offer. But once they accept it, it becomes contractually binding on you. So be very careful. People use these terms interchangeably and they refer to OTPs from beginning to end. It's not technically correct, and sometimes it does cause confusion, but all you need to know is that an OTP typically is the same thing as a contract. Only legal difference is that a contract has actually been accepted by the seller. So that is when the seller says, yes, I will sell you the property for 1 million rand. Now, there's 3 little basic things that everyone needs to know about OTPs so that they don't get them wrong. And why it's important that you don't get it wrong is because our laws are actually quite strict on the format of an OTP. So very few contracts are laws strict on. Most contracts can actually even be oral, and I can agree to do something, and that's it. It's actually a contract between you and I just because I've said it. With properties, that is not the case. Very important, not the case. Never make an offer that's digital. Never make an offer over just an email. Never make an offer simply by stating that you're making an offer. Because if the seller accepts this, it is still not binding. You cannot force the seller to sell you the property. So be very, very wary of making an offer unless you've signed it by hand. And if there's an estate agent that starts arguing with you that it's okay, do it that way, you refuse to do it unless you understand the risk and you want to submit it anyway just to see what the reaction is. But at some point in the transaction, you have to ensure that you get the original contract. So I'm going to run through this so you guys understand the nature of the contract, and then we can move on to the more entertaining stuff, which is the specific clauses. So like I mentioned, offer and acceptance, all contracts that you enter into in South Africa need to comply with that first pillar, which is your normal essential elements of a contract. So it means the parties need to agree. It means that the parties need to have a legal capacity to act. They can't be insolvent or they can't be minors. It means that the performance must be possible. You can't sell something that isn't yours. You can't sell something that's been destroyed. The performance must be possible. It must be lawful. And the consequences must be ascertainable. So when putting in specific clauses in the agreement, just make 100% sure that it's determinable. So if you don't pick a purchase price, it needs to be able to be calculated, because if it's not, then it's not going to be a valid agreement because you guys have not decided on the actual consequences. It hasn't been determined. Second thing that you need to remember is specifically when it comes to sales, in addition to that first part, the second part is there needs to be an object that's subject to the sale. So that's you're going to deliver something, and in exchange, you're going to receive something. So it's an asset for consideration. It's sometimes even an exchange. Any sale is basically you taking something and you're going to become owner of that. So you're not borrowing it, you're taking it and you're giving something in exchange for that, even if it's just 1 rand. Now, the important things to remember are the very specific requirements in terms of the Alienation of Land Act with respect to the content and the form of this agreement. So just so you guys know, has to be in writing. You cannot do this without it being in writing. The parties need to be easily identified. So you can't make an offer and, the seller's not written there and it's not specified. It has to be properly specified. Every party needs to sign the contract or their agents. And if it's their agents, it needs to be written authority. And very, very important, remember when I say in writing, it means wet ink. So it's also not simply about having a digital version that you email. It has to actually be signed by hand with pen. Yes, that sounds extremely archaic. It's not the ideal scenario. The legislation is quite old though. So it's from 1981. Yes, certain changes have been made, but as it stands at the moment, the changes haven't encompassed digital versions of the agreement. So for now, we simply rely on wet ink versions. Now, somebody might come and tell you, and you'll hear this all the time from agents, oh, but I do plenty of sales. Don't worry about that wet ink thing. It doesn't matter. The transactions still go through the deeds office. And that's true, right? Except for those that don't. So transactions will go through the deeds office. If no one notices, no one raises any issues, the deeds office doesn't check, the conveyancers sometimes don't mind, the agents sometimes don't mind, the transaction flows naturally, no issue at all, gets registered at the deeds office. The ones that don't are obviously the examples of the transactions where either the seller or the purchaser is trying to find excuses to not proceed with the transaction. So you might, for example, find a seller that suddenly changed his mind and no longer wants to sell the property. So in that instance, the seller decides that they don't want to transfer the property. Similar with a person buying the property, sometimes they change their mind later on, especially as property investors, because with property investors, there's that risk that you're buying, but you're trying to sell it on to somebody else. So we see that a lot with sourcing agents. Again, in those examples, you're trying to find a way out of this contract. Obviously, if it's not in wet ink, it's a very easy way to get out of the contract because the contract is not valid under those circumstances. So those are the primary things. Those are fundamentals. And that's pretty much really all you need to know about the very basics about an OTP and the contract itself when it's accepted. Now, as property investors, there's an extra step to all of this. And this is when you start speaking about very specific clauses. Now, specific clauses, by this I mean every OTPs aren't made equal. And that's the reality. Is an OTP from an agent may, for example, contain very similar clauses to that of other agents, but that is they're not always identical, and they don't always contain similar clauses. So that's the first thing that you need to bear in mind. Just because you're signing something that's called an OTP doesn't mean that you're signing the same standard document that everyone uses. These documents are bespoke, and sometimes it's up to you to ensure, number one, you understand what the difference is. So there are differences between OTPs. So you need to be able to understand these differences. You need to be able to identify what this OTP says and how it impacts you. And that is crucial, and you need to be not courageous, but you need to have the confidence to be able to change this OTP so that it suits you best. Now, between you and I, a little trick that I normally suggest to property investors is that you guys, please use an OTP that you're familiar with. So I have one on my website as an example. I often, it's dished out for free. You can download it from the website. But what I often suggest is study this OTP. Get to know it, all right? Make that your standard OTP so that every time you read any other OTP, you're able to identify the differences between them. And this gives you a strength, because if you're comfortable with mine, for example, and you're comfortable with all those clauses, and that's how you want to approach a property deal, when you read something else, you understand the deviations aren't usual, and you start asking the right questions as to why the deviations aren't usual. So that's something to bear in mind. Not all OTPs are the same, so you'll see that there's a variety of different clauses that one could select and that one would find in an OTP, but each one of these might have different consequences depending on whose OTP it is and how the seller has actually wanted to structure the deal and how the agent has paid attention to the seller's instructions in structuring the deal. So the first thing that we look at is parties. Now, with parties, it's a very quick conversation because we're not going to be able to go into this in detail. There's two components. There's the seller and there's the purchaser. So there's two sets of parties that one needs to pay attention to, right? I normally have structuring conversations with my clients where I make recommendations on how they should buy properties, whether they should buy it in a trust, whether they should buy it in a company, whether they should buy it in a company that's owned by the trust, a variety of different options that a person has. This carries with it certain tax consequences, asset protection benefits, and obviously the ability to procure finance from finance houses. Whatever selection you make will impact you. And because it's such a big decision, it's very difficult to rectify this later. So usually as a business owner, you'd want to make the decision ahead of time before you start investing capital into a business, only to realize later that you're paying double the tax that you should be paying, that you risk For example, when you pass away because your estate planning wasn't done properly, you risk having to pay 20 or 25% of the value of your estate, sometimes even more because there's other costs. We did a calculation recently where the cost actually came up to 33% of the estate. So be very, very wary on how exactly you're buying these properties. You buy it in your own personal name, you're going to pay estate duty, you're going to have huge asset protection risks because now the properties are in your own name and can easily be attached if anything does go wrong. You want to buy it in companies, you want to buy it in companies under trust. If you're a serious property investor, this is the first step. Even before the OTP, you start looking at this. Make sure that your OTP, though, has the right party inserted from your side as a purchaser. As a seller, always be very wary about who is selling the property. Always double check it's the right person. Make sure that your conveyancer checks that it's the right person. So it's the second thing when it comes to the parties that you need to bear in mind. Is the seller the right person? Is the seller authorized to sell the property? Now, under most circumstances, this isn't an issue. You'll do a deed search, the person owes it in their name, and he signs the contract, it's all good. Where sometimes we experience difficulties is with companies, as an example, where only one director decides to sell the property and the other director isn't around. So make sure your conveyancer or the conveyancer at least verifies that there is a proper resolution in place to have signed the contract before you go and spend any unnecessary money on the transaction, only to realize that it can't go through. So leave this to the attorneys, but make sure that you ask, because some attorneys won't poke at this, and it's definitely a question that must be asked when taking the mandate, is whether the company is actually authorized to sell, whether the trust is actually authorized to sell. So the next thing very quickly is your deposit, penalty, and breach. Now, why I've grouped these together is because they're the financial component, the financial / penalty component to the OTP. This is things that you need to look out for as a property investor. Now, important things to consider. So a deposit, once you've paid it out, right, it sits in the conveyancer's trust account. Once it sits in the conveyancer's trust account, guess who doesn't want to get rid of it? Is the seller. Because this is the only security that the seller has in order to be able to ensure that the transaction goes ahead. So if, for example, you decide to breach or you decide to walk away, I can almost with all certainty tell you that the seller will try get their hands on this deposit in order to be able to recoup damages, as it were. So be very, very careful with that. Your deposit, once you let it go and it goes into the conveyancer's trust account, you've partly committed. And even though you may feel that you get your deposit back if the sale doesn't go ahead, that's not always the case, and I'll explain to you why. Now, remember, as a property investor, there is no obligation for you to pay a deposit. So if you can get away with 100% bond, as an example, and you don't want to pay a deposit up front, you can. Even as a cash deal, it doesn't mean that the cash has to be paid. You can sometimes even retain the cash. So let's say you've got R1 million. Let's say you've got 500,000 Rand and you're going to get the other 500 from a bank. It doesn't mean that you have to give that 500 Rand cash to the conveyancer. You can actually take your cash and ask your bank to please issue a guarantee, or you can ask us, like we do it for clients all the time, where they're entering into cash transactions. They're giving the money into our trust account, even though we're not the conveyancers, and we issue a guarantee to the conveyancers for that sum of money. And that is a legitimate way of doing it. There shouldn't be any issue with it unless they want the cash in their bank account. So that is an option for someone that doesn't want to part with large chunks of cash. They can actually offer guarantees instead. So that's definitely an option to consider. But no obligation to pay a deposit. So if you did want to buy 100% cash and you'll give the guarantee, but you're not going to pay a deposit, that is allowable. Next thing to consider when it comes to a deposit is why, and I've explained this somewhat, especially when it comes to the seller's need or want for a deposit. As a purchaser, there's no real desire for you to pay a deposit. If you can hang on to your money as long as possible, that is the ideal scenario. But if you're selling, it's the flip side of things. You actually want the purchaser to put skin in the game. So you want to see cash before you start committing yourself to the idea of there being a transaction in place. So that's just certain things to consider, is when it works for you and when it doesn't work for you. Now, the next thing, penalty. And how this is tied to a deposit is the fact that most of these contracts, and mostly standard, have a clause about it. Either refers to row crop, or it refers to forfeiture, it refers to an estimated damages, or pre-liquidated estimate of damages. All this means is it's a forfeiture, right? It means that if the transaction doesn't go ahead due to a breach on your part as a purchaser, the seller will retain the money, right? Now, this is one style of penalty clause, which is it's basically everything. It doesn't cater for a portion of the deposit. It caters for the full deposit being retained. And so just a little bit of like a little red flag or warning so that you guys are aware of this. It's not actually always the case that the seller will be entitled to retain the full deposit, even if the contract says so, because there's legislation in our country that prohibits, or not prohibits, but gives the purchaser an opportunity to challenge whether the penalty was actually appropriate and not overkill. Because it does so happen that you pay a deposit of R1,000,000, the seller doesn't suffer any damages, and now they want to keep R1,000,000 just for the sake of it. The courts have found that is not fair and are willing to grant orders returning a portion of the deposit and allowing the seller, yes, to retain a proportionate portion that is proportionate to the damages that they actually suffered. So just so you know, penalties, just because they're in the contract, doesn't mean that they can just be enforced outright. But what you typically do find with penalties is the sellers try, and that deposit normally gets retained for long periods of time while you try fight to get it out. So don't pay the deposit and just expect that you're going to pull out the Conventional Penalties Act and say, give me my money back, you're not entitled to it. It doesn't work like that. You're probably going to need to prove that they're not entitled to it. And because that is an arduous process, you're not going to have that cash in hand. So just be very careful. If you're going to commit to a deal, commit to a deal. Don't simply just expect that you're going to get all your money back because you've changed your mind. That is not, unfortunately, how it works. Then conditions, very, very important. Suspensive conditions. What is a suspensive condition? Simply put, a suspensive condition is a condition that renders the contract suspended until it's fulfilled. So it's quite simple. You enter into a contract, you make an offer, but the binding nature of the contract is halted until something else happens. More often than not, it's getting money from a bank, right? If you don't get money from the bank, this contract basically disappears. It lapses. It's like you've never signed it. If you do get money from a bank, contract becomes enforceable and comes into play. So that's the most typical suspensive condition. As property investors, and this is a topic all on its own, as property investors, you would actually want to also include things like, I want to see if I've got it on my next slide now. You want to include things like due diligence. You want to specify the level of due diligence. You want to specify how long you have in order to conduct this due diligence, because sometimes you don't want to spend money on, let's say, even property inspectors or any sort of contractors to go out that will price you for doing certain quotes, so that you can comfort yourself with the property and then not yet have secured it. With a suspensive condition, what actually happens there is you've secured the deal. You've secured it, subject to your suspensive condition. So it works in your favor. And because it works in your favor, it means that if it turns out that your due diligence is successful, all good, contract goes ahead. So you have tied the seller into the transaction. So all that money that you've spent on the due diligence is good. It's tied in. If you do the due diligence prior to making an offer with a suspensive condition, you've paid that money, but you haven't guaranteed that the seller will actually sign the contract. So suspensive conditions are a very, very nifty way of being able to tie the seller in, so that when you spend money on due diligence, you're actually able to tie in the seller. And then just small little ones that to bear in mind are things, for example, like footstoots. And be very, very careful with the footstoots clause. I've got it here. Very careful with the footstoots clause, because as a buyer, if you enter into a contract with another natural person and it's not subject to the Consumer Protection Act, a footstoots clause would basically mean that you're buying the property as is. And if you later find out that there's issues with that property, it's not the seller's problem. And the only time that this does not apply is if the seller knowingly sold you the property, but knew that there were issues with it. And I can promise you, it is extremely difficult to prove that the seller knew, right? There are ways of doing it, but it's going to take you a lot of effort and a lot of time. So if you buy a property and it's footstoots and you can't prove that the seller knew that there was something wrong, and the seller is not subject to the Consumer Protection Act, be very, very careful. If, however, you're buying from property investors or developers, then it's a different story, because Consumer Protection Act should protect you. It's when you're buying from that individual homeowner that used to live on the property, be very wary, because he might be able to hide behind a footstoots clause, even though you suspect that he knew that there was that issue with the roof or the geyser or the swimming pool or whatever the case is. Appointment of conveyancer. You can negotiate the appointment of a conveyancer. So I would always suggest, if in practice the seller appoints it, but as a purchaser, because you're paying the costs, very often you are able to motivate it, but it is a motivation. So I'd always suggest that you try, simply because you also get to control the transaction a bit more with less bias, because the conveyancer for the seller will obviously want to impress the seller, as opposed to the conveyancer for the purchaser that may very well want to impress the purchaser, although legally speaking, the conveyancer should act relatively impartially. Unfortunately, this is just an observation that in practice, you do tend to find that there's a bit more leniency towards a seller by the seller's conveyancer. And I normally touch on these alternatives, but I think I'm going to leave that for today because we're out of time. Maybe in the next session, we can have a conversation around different alternatives, especially when it comes to the buying space, and things that may assist you in acquiring these deals by using OTPs or not using OTPs. So these are just different ways of investing that collectively you can use with the OTP. But I just want to thank everyone. Kali, I don't know if you're still there, but I just want to thank everyone for their time today. I hope you guys got value out of this. And yes, hopefully we get to do this again sometime. I don't see any questions. Kali, do you?
We don't have questions on our side as well, but thank you very much, Bruno, for joining us and sharing this valuable information with us. And thank you for everyone who attended. Thank you.
Cool. Thanks. Cheers.